Hey out there, legal warriors. In this video, I'm going to cover why you should not hire a family law attorney to try to remove your criminal no contact order. Same way you don't want to hire a criminal attorney to go in your family law case, but it's really important because we've seen this problem happen from time to time. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like it, please subscribe. More people get to see it, more people get the help they need. Now I'm just going to jump right into it. A criminal no contact order is a lot different than a civil protection order or a civil restraining order. Protection orders happen under RCW 7.105, and civil restraining orders happen as usually part of a divorce or something like that, usually under RCW 26.09. So now, a criminal no contact order is based upon either an arrest for typically a domestic violence charge or a conviction of a domestic violence charge. And so the most common fact pattern that we see is that someone gets arrested and a pretrial no contact order gets put in place. And I've got a lot of videos here on my channel where I speak to alleged victims where they're asking to try to get a no contact order dropped. There's a few educational pieces they put out about how to improve the chances if you're a person who is protected by a criminal no contact order and you don't want one anymore. But sometimes people feel overwhelmed and they want to go get an attorney to try to help them remove that criminal no contact order. Now, Lance, why can't the defense attorney just remove it, right? Why can't we just make it go away? Well, because the defense attorney represents the defendant, the person that is restrained by the order. And the court has often issued a criminal no contact order restraining the defendant over the objections of the alleged victim to begin with. Oftentimes, these non-felony type cases, there's situations where, lots of reasons why it happened. Maybe alcohol is involved, maybe it's sort of a de minimis case, but oftentimes the protected person, the alleged victim, doesn't want to have their entire family and life disrupted by a court order when they don't think they need one. And so when they look to hire an attorney, they're trying to get sort of their story listened to. They're trying to get more traction in the court. They're trying to make it more likely that the prosecutor or the court is going to listen. Us defense attorneys, of course, we shouldn't be going in there and asking to remove protections for someone that's not our client. It's really not a good look. So what can happen is, let's say you already have a family law attorney, you're an alleged victim in a case, or you don't know what to do, you end up calling the family law attorney. What can happen? Why is that usually not a good idea? Because typically speaking, unless a family law attorney also has a very active criminal practice, they sort of have no idea how to do it, right? They have no idea how to even get the matter noted on a calendar, what dates it might happen, and the court doesn't typically go out of its way to help people practice law, right? And what really can go wrong is they don't typically know to argue the correct things, because there's a difference. There's a difference between family law, which considers all different types of things in equity, right? It can look at prior bad acts, who's right versus who's wrong in the past, right? It can take a look at what's in the best interest of the child and stuff like that. And it's just, a guardian ad litem report might say X, Y, or Z. And all those things are relevant in this very deep dive in a family law case. But a criminal case, it's just simply not something the court cares about. Remember, in almost every criminal assault type domestic violence charge, it's going to go in front of a court that never does any type of family law, right? A district court judge doesn't hear family law cases. A municipal court judge doesn't hear family law cases. Commissioners hear family law cases, and they don't handle crimes. And so all the stuff that a family law attorney comes in that's really effective when they're talking to a commissioner is like speaking a foreign language to a judge, right? That doesn't do that type of work. What the judge cares about, it cares about protecting the victim. One thing only, protect the victim. They don't care if the victim's done bad in the past. They don't care about who's right and who's wrong. It's not a fight over property or custody or those type of things. They care about one thing. And so the family law attorney comes in there and starts bad-mouthing, the prosecutor, not a good idea, starts, arguing about, hey, well, my client, this alleged victim has done stuff wrong too. Never want to do that, right? What a good attorney needs to do in arguing on behalf of their client, if they're representing an alleged victim, is talking about, hey, I'm not afraid. I'm not afraid of the restrained party, the defendant, right? I also don't want my agency taken from me, right? I want to be able to make my own decisions as an autonomous adult. I don't need the court deciding for me. And hey, I hear that the defendant is doing some classes and stuff like that. What a family law attorney doesn't necessarily understand is what we're trying to do is make the court comfortable in letting the alleged victim make his or her own decisions. And part of that is taking a look at what situation is different at the time the request to change or drop the order comes in than when it got put in place, right? Day one, during the arrest. And so the timing is so important. The older the case is and the more the defendant has done, domestic violence MRT classes, anger management classes, alcohol classes, if alcohol is involved, the more likely the court can feel comfortable in now listening and honoring the wishes of the person that is protected, right? The alleged victim. And you also have to know the prosecutor. Family law attorneys can think, oh, I can just go tell the prosecutor, right? They'll do it. They're going to listen to what my client wants. And it's exactly the opposite. Almost all prosecutors will very rigidly hang on to that no contact order because it's part of their power in the case, right? They don't want the defendant influencing the alleged victim. They don't want things happening that's going to hurt their case. And so when a family law attorney comes in, it's very frustrating at times for a criminal defense attorney because they simply are not speaking the same language as the court. Same way, if I were to try to go into a family law case, and let's hope I never have to, I don't speak the same language as the court coming from the criminal defense perspective. Now, we do defend a lot of protection orders, and while they're not family law matters, commissioners decide those, and they hear a lot of family law cases. And so therefore, I have become educated on how a family law commissioner thinks and the words that they use. But again, in the criminal court, it's 100% has zero to do with family law. Superior courts handle family law cases, and for non-felonies, they're district and municipal courts that handle criminal matters, and therefore it's really a recipe for disaster. So this is not to say anything bad about family law attorneys, and if you have a family law attorney that also practices criminal, well, that doesn't apply to that situation because they're going to hopefully know, if they have a big enough practice, of what works in each court, with each judge, with each prosecutor, and what are the magic words and the magic things that need to happen so the court will drop a no contact order pre-trial. And remember, if you're out there with a no contact order and you're the protected party and you don't want it, well, it's not your order, it's the court's order. And it may say there's a 5-year expiration, and it's not really 5 years. That's sort of a default. I've covered this in other videos. They're going to readdress it when the court case resolves. And oftentimes when the court case resolves, the court takes a different opinion. It's like, oh, the case is over. If the prosecutor's okay with it, I'm okay with it, right? And why don't orders go away? Because the prosecutor almost always is not okay with it. Now, again, your mileage may vary. If you have a really competent and highly skilled and broadly cased defense attorney, they're going to know which prosecutors are comfortable sometimes agreeing, right, to drop an order early. They're going to know which victims' advocates are more comfortable recommending it. But as a rule, most prosecutors are going to be against it because there's only risk in it for them, right? I was a prosecutor. I didn't want to just drop no contact orders because what if I agreed and told the court, go ahead and drop the order, and now my alleged victim ends up dead, right? Then who's going to get looked at, right? Who's the one that's supposed to be protecting the alleged victim? And so that's why it's not as simple as equity or logic, and that's why you need someone who's experienced in this type of law for such an important thing. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you've got a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.